As per criminal procedure, if any offense has been committed by any person who is arrested by the police authorities, if the investigation is not cannot be completed within 24 hours, that accused should be produced before the magistrate, and that magistrate shall authorize the further custody either to the police or in the judicial custody. So that provision is section 167 of CRPC and now 187 of BNSS. So this video is all about remand of accused to the police, and which is police remand, and the other remand is judicial remand, which is always in the custody of jail authorities. So we will discuss remand and what changes are introduced in law of remand under BNSS. So we will discuss the provisions and the relevant case laws, and what is the maximum period for which remand can be made. So first we must know that what remand really is. Remand in general means that to send someone who's accused of committing a crime away from the court until trial begins. So sending accused in the custody of either police or to the jail authorities during the pendency of trial, that sending of accused to either of these custodies is called remanding the accused. So now we'll discuss the objects of remanding the accused. So as per section 187 or 167 CRPC and BNSS, the remand there in that provision is pre-cognizance stage, where there are remand can be at two stages, either pre-cognizance or post-cognizance. Post-cognizance stage remand, there are other provisions for that, but 187 provides only for remand at pre-cognizance stage. So there the investigation is going on, the arrest has been made and investigation is going on. This is the stage. So there the first object is that to ascertain whether the arrest and detention is legal or not. So there must be legal arrest and detention of the accused. So the magistrate shall ascertain that the detention, the arrest has been the legal arrest, detention or not. So then it is also the object of remanding the accused that if he is arrested and detained, if he is remanded to the police custody or judicial custody, there are chances that investigation and the fair investigation can be done by the police authorities. If he is not absconding, then there are chances that he will not be tampering with the evidence, and if evidence cannot be tampered or the witnesses are not being dissuaded by the accused person, then obviously there will be a fair trial. So these objects are interconnected, and then again if remand is to be made by the magistrate, and magistrate, the provision of remand is there that the further custody after 24 hours to be allowed only by the judicial magistrate, then in that case obviously the rights of the accused are being looked into. If there is any violation of fundamental rights, or is there is an illegal arrest by the police, or whether there are the right accusation, that can be scrutinized, and this would be the discretion of the court that whether remand must be made or not. And in that stage, even the court can, instead of remanding the accused, can grant him bail. So these are the objects of the provision of remand there in the criminal procedure. Now, as I mentioned, there are two stages of remand. There can be two stages of remand: remand at pre-cognizance stage and remand at post-cognizance stage. Now, pre-cognizance stage is provided under section 167 of CRPC and 187 of BNSS, Bharatiya Nagrik Suraksha Sanhita, which has been now enforced from 1st of July 2024. So 187 provides for remand. Earlier in CRPC, 167 was there, which was the same provision of remanding the accused either to police custody or judicial custody. Now generally the remand at pre-cognizance stage is before filing of the charge sheet. It is done before the filing of charge sheet. After the filing of charge sheet, the magistrate takes the cognizance of the case as the charge sheet is filed to the court, and then it frames the charges, take the cognizance, and the trial is to be conducted by the courts. So in that case, after filing of the charge sheet, it is remand at post cognizance stage. Before filing of the charge sheet, it is either in the police custody or judicial custody, but after filing of the charge sheet, the remand is at post cognizance stage, and that can only be done can only be authorized in judicial custody. So it is to be remembered that remand at precognizance stage can either be police remand or judicial remand. Now there is to be now further subject of discussion. The provision must be read properly that the police remand can be of 15 days even in BNSS and was in CRPC, but judicial remand can be more than for 15 days, as there is a also limitation of 60 and 90 days in 187. But at remand at post cognizance stage, the certain time period is not there for how for how long the accused can be during the trial can be put to the judicial remand. But yes, as there is a provision of bail which says that nobody should be kept in detention for more than half of the sentence provided for the offence for which he is alleged to have committed it. So these are the provisions. Now we will discuss what is the provision of remand there in CRPC and as well as BNSS. Now BNSS is enforced, so we will definitely discuss 187 and what new has been introduced, what changes are brought into. We will discuss those changes. As I mentioned, and remand can be either in police custody or judicial custody. So police remand is detention in police lockup at police station. This is police remand, where the accused is kept in immediate custody of the police. That is police remand. And judicial remand is detention in jail. So jail means that in the custody of the superintendent of jail, and there is also jailer who takes care of the accused detained there during the trial or even during the investigation of the offences. Now remand at precognizance stage is provided under section 187 and of BNSS and 167 of CRPC. So subsection 1 provides that whenever any person is arrested and detained in custody, whenever any person is arrested and detained in custody, it appears that the investigation cannot be completed within the period of 24 hours as provided in section 58 or 57 of CRPC and 58 of BNSS. So whenever any person is arrested and detained in custody and it appears that investigation cannot be completed within 24 hours as given under section 58 of BNSS and 57 of CRPC, that and there are grounds that accusation or information is well founded, the OIC, officer in charge of police station, or the police officer making investigation not below the rank of sub-inspector, right, shall forthwith transmit to the nearest magistrate a copy of entries in the diary as well as the accused. So if somebody is arrested, detained, and investigation cannot be completed within 24 hours and grounds exist that accusation or information is well founded, then either the officer in charge of police station or the police officer making investigation, if he is not below the rank of sub inspector, shall transmit to the nearest magistrate and with a copy of entries in the diary as well as the accused. And then in subsection 2, the magistrate to whom an accused is forwarded, whether he has or has not jurisdiction, whether the magistrate having jurisdiction or not, after taking into consideration whether the person has been released on bail or his bail has been cancelled, authorize from time to time the detention of the accused in such custody as magistrate thinks. So it says that the magistrate, whether he has jurisdiction or not, after taking in consideration whether the accused has been released on bail or his bail has been cancelled, authorize the detention of the accused, which means it will authorize the custody as he thinks fit, to such custody as he thinks fit. So either in police custody or judicial custody for a term not exceeding 15 days in whole or in parts at any time during the initial 40 or 60 days out of 60 or 90 days of detention period. So you notice that as per 167 there in CRPC, there was a mention of police remand only for 15 days. Here there is no such terms used. That subsection 3 provides that there can be maximum 60 or 90 days of detention before the up to the filing of the charge sheet, and after the completion of these 60-90 days, the right of default bail arises. So in out of those 60 or 90 days, during initial 40 or 60 days, a total 15 days in whole, the police remand can be authorized by the magistrate. This is the interpretation, although there is no direct mention of the police remand here, but recently the union government clarified it that even now the police remand can be only for 15 days. But what change they have introduced is that 15 days time period can be allotted in different parts during 40 or 60 days of total detention period provided under subsection 3. So this is the new provision introduced in 187, which was not there in 167. And then in case if the magistrate doesn't have jurisdiction, if he is not having jurisdiction to try the case or commit it for trial, and he considers that further detention is unnecessary, the remand is obviously allowed when the magistrate finds and considers that there is the necessity of remanding the accused for further custody. So in case he is not finding necessity of further detention, and if in case he is not having jurisdiction, then in that case he shall forward the accused to a magistrate having such jurisdiction. And then, as I mentioned, that subsection 7 of the 187 provides that whenever the detention in the custody of police is authorized by a magistrate, he shall record his reasons for doing so. So without reasons, authorizing demand without reason is a violation of subsection 3. So there must be express reasons to be shown by the magistrate when he is authorizing custody of detention in the custody of police. So this is subsection 7 of the 187. Now subsection 3 provides that magistrate may authorize detention of detention beyond 15 days as mentioned in subsection 2. He is satisfied that adequate grounds exist. So beyond 15 days detention can also be authorized, but magistrate shall not authorize the custody for period exceeding 90 days when offence is punishable with LI, death, or for 10 years and more, and 60 days in any other case. So whenever the offence is the allegations are for offence punishable with death, LI, or for 10 years or more, in that case the maximum detention can be for 90 days, and in other cases for 60 days. So less than 10 years is the punishment for any offence, then the 60 days would be the maximum period for which the detention can be authorized of any accused. So after the completion of this 90 days or 60 days, if challan, the charge sheet, has not been filed, then arises the right of default bail, and then in that case the accused has a statutory right to get bail after 90 or 60 days are over and challan has not been filed. So this is provision of default bail, where the accused is prepared and he furnish bail there, and 19 and 60 days are over and no charge sheet has been filed by the police. So he gets the bail. Now explanation says that, explanation 1, that accused shall be detained in custody so long as he does not furnish the bail. So you have, even if there is a right of default bail arises, and if you are not prepared to furnish bail, even in that case your detention shall be continued unless you furnish the bail. Now again you find out that in beyond, as it is written there, that authorization of detention beyond 15 days, there is no mention of whether it will be of police remand or judicial remand, as there is a clarity under section 167. This provision, neither during 15 days they have clarified that whether the detention would be can be only police custody or judicial custody. Even after 15 days detention, there is no such mention of whether it will be judicial custody or police custody. But as I stated, that union government has already clarified that the police remand as earlier can only be for 15 days initial, not initial, but during 40 or 60 days time period as mentioned in subsection 2, but for maximum 15 days. So earlier in 167 the interpretation was that the police remand can be only for initial 15 days, but now in BNSS under section 187 they have provided that although police remand can again only be for 15 days, but those 15 days can be distributed and divided in different parts up to time period of 40 or 60 days. Now subsection 4 provides that no detention shall be authorized in custody of police unless the accused is produced before magistrate in person for the first time, and subsequently every time till the accused remains in the custody of police. So before authorizing the custody in police, the magistrate shall assure that the accused is produced before him in person,
for the first time and every time subsequently if he authorizing the custody of police. So not in case of judicial custody, where it provides that detention in custody, judicial custody may be extended on production either in person or through the audio video electronic mode. So in case of authorizing police custody, the presence of the accused in person is for the first time, and every time the custody is being authorized, his physical presence, in person presence is required. And in case of judicial custody, it may be extended on the production either in person or through the audio video electronic mode. Now explanation 2 of this provision provides there that the presence of accused at the time of remand may be proved by the signature on the order authorizing detention. In case of presence through audio video mode, presence may be proved by the order certified by the magistrate. So presence of accused at the time of remand may be proved by his, if there is a, if occasion arises whether he was present or not, it can be proved by his signature on the order authorizing the detention. Whereas in case of presence to be proved where it was through video audio mode, it can be proved by the order certified by the magistrate. So this is explanation 2 of 2 in this regard. Now subsection 5 of 187 says that no magistrate of second class not especially empowered by the High Court shall authorize detention in the custody of police. So as per this provision, if you interpret it that it bars, there is a bar for remanding the accused to police custody by second class magistrate unless he is empowered by the High Court, but the bar is only for the custody of police, not for judicial custody. So this is subsection 5. Now there are two provisos. One says that a woman under 18 years of age, the detention shall be authorized to be in custody of a remand home or recognized social institution. So women under 18 years of age is there and she is detained, then her custody shall be only in a remand home or recognized social institution. And proviso 2 provides the police custody shall be in police station and judicial custody in prison, and or a place declared as prison by the state government or central government. So this is, as we earlier discussed, that the police remand shall be in the police station and judicial custody is in jail, which is prison, and that can be a place recognized by the central government or state government. Now subsection 6 provides for a situation where the judicial magistrate is not available. So where magistrate is not available, then police officer or IO he will transmit the accused and case diary to the nearest executive magistrate on whom powers of a magistrate has been conferred. So, and then executive magistrate shall, after recording reasons, authorize the detention for not exceeding 7 days. So where the detention, the judicial magistrate is not available, then detention shall be authorized by the executive magistrate who is nearest to the area, and he cannot authorize detention for more than 7 days in aggregate. And then on expiry of the period of detention so authorized, the accused shall be released on bail except where the further detention by a competent magistrate is authorized. So where it is not possible after 7 days that the further detention can be authorized by a competent magistrate, judicial magistrate, then in that case he shall be granted bail, the accused shall be granted bail after the expiry of 7 days as provided in this column. Now detention order by EM shall be taken into account in computing the period specified in subsection 3. So if after the 7 days if judicial magistrate is authorizing further detention, then 7 days shall also be counted as which were authorized by the executive magistrate. Now there is a proviso which says that before the expiry of the set period of detention, the EM shall, executive magistrate shall transmit the nearest judicial magistrate the record and copy of the entries in the diary of the case. So now subsection 8 says that if any magistrate other than CJM making an order of remand, then in that case a copy shall be sent with reasons to the chief judicial magistrate. Subsection 9 says that investigation, in cases of investigation in summons cases, if the investigation is not concluded within 6 months from the arrest, the magistrate shall order stopping of further detention unless the IO satisfies with the special reasons and in the interest of justice the continuation of the investigation beyond 6 months is necessary. So in summons cases there is a provision that investigation should be completed within 6 months, otherwise there must be some special reasons, and as if my magistrate allows that in the interest of justice the further investigation should be allowed beyond 6 months. So this is subsection 9, but subsection 10 also says that if stop the further investigation has been stopped by the magistrate there under subsection 9, then the same can be challenged before court of session, which can vacate such order on satisfaction that further investigation ought to be made and direct that further investigation subject to such directions to bail and other matters as may be specified. So this is subsection 10, and court of session can vacate the order of stopping of further investigation by magistrate under subsection 9. Now, under section 187, we discussed remand at precognizance stage. Now, remand at precognizance stage is provided under section 346 of BNSS, which was 309 of CRPC, and 232 of BNSS, which was 209 of CRPC. Now, 346 provides that it authorizes the court to remand an accused to custody from time to time by issuing a warrant while adjourning the proceedings during trial. So 309 is for generally provides for adjournment, but when adjournment is being made by the court, in that case the court to remand the accused to in judicial custody from time to time by issuing a warrant while the proceedings are adjourned. So it is during inquiry or trial, and that the proviso is there that it shall not exceed 15 days at a time can be there. So it is remand in custody when the proceedings are adjourned, right. Now it is to be remembered that such remand under 309 and 209 can be there only when the accused in custody, not when he is already on bail. If he is already on bail, then no occasion arises that he is to be remanded. But if he is in custody, then 309 provides that if court is adjourning the proceedings, that then in that case the accused can also be remanded, but not for more than 15 days at a time. Now section 232 of BNSS provides that when magistrate is committing a matter to court of session, it can remand accused to custody when he is committing the case to court of session if matter is triable exclusively by the court of session. So this is also a case of remand at post cognizance stage. So these were both provisions of remand at post cognizance stage. Now we are going to discuss some important cases regarding remanding the accused. So in CBI versus Anupam J. Kulkarni 1992 3 SCC 141, here in this landmark judgment, the court says that the police remand cannot be for more than 15 days from the date of arrest. So this is a landmark judgment where the law was settled that the police remand cannot be for more than 15 days. And here in Arnish Kumar versus State of Bihar 2014 8 SCC 273, in this landmark judgment it was held that where the punishment for the offence is less than 7 years, a notice of appearance under section 41A of CRPC should be served on the accused instead of arresting by the police. Now in exceptional circumstances where the reasons in writing are recorded by the police, in those cases arrest can be made, but otherwise 41A notice should be there in cases where the punishment is less than 7 years. In that circumstance where the notice should have been issued to the accused as per Arnish Kumar and the detention is there, then it is the duty of magistrate to scrutinize the same, and if there is the detention is violation of Arnish Kumar, then the further detention should not be granted by the magistrate. So magistrate should grant him bail instead of granting further custody. Otherwise, as per the various recent judgments of Honorable Apex Court, if Arnish Kumar is violated by the police or the magistrate, there is a contempt against the that judgment. So this is the judgment of Arnish Kumar with regard to where the arrest has been made and the remand is to be made. It must be ascertained that there must be special reasons where the case is punishable, offence is punishable with less than 7 years. In more than 7 years punishable cases, there is no application of Arnish Kumar. Further, in recent judgment of Honorable Apex Court, Enforcement Directorate, Government of India versus Kapil Vadhavan and others, it is a judgment of 2023, and here in this case it was held that the day of remand to be included for considering a claim of default bail and the stipulation of 60-90 days remand period under 167 CRPC ought to be computed from the date of when the magistrate authorizes the remand. In cases where the charge sheet is filed on or after 61st or 91st day, the accused would be entitled to default bail. So earlier this was the judgment of Honorable Apex Court that the day on which remand order is passed, that should be excluded for computation of the time period of 60-90 days, but that has been overruled now. The day of passing the order of remand should also be counted, included in computing 60 or 90 days time period. And so this was all about the remand under BNSS. I have also made a separate video there available on my channel of section 167 CRPC, and of which I'll share the link in my description. Thank you so much for watching.